Excellencies and ladies and gentlemen and distinguished colleagues, again, William Pace and I have been honored for these many years to be the convener for the Coalition for the International Criminal Court, a global network of non-governmental organizations, of global civil society from almost every sector that has an investment in fairness and justice and rule of law and human rights. It's one of the largest networks in the world, and we're in our 24th year at this point. Over 3,000 NGOs around the world are the member organizations of the coalition. And our goal for the last 2 years, as I mentioned, has been to try and make the 20th anniversary not only an important commemoration of the adoption of the Rome Statute on July 17, 1998, but a serious opportunity to take stock and to advance and strengthen the Rome Statute system. We were very, very pleased with the participation and of everyone who joined us at the International Criminal Court yesterday for our launch. We would like very much to re-emphasize that we hope this is a launch, that we hope that there will be many, many commemorations around the world this year. Yesterday, and today, we've been highlighting especially participants who were leaders in Rome of the drafting, adoption of the Rome Statute, of the ratification and the preparatory commission in the United Nations General Assembly, and the early establishment of the International Criminal Court. Of course, we will continue with those leaders today that will participate, and we will, of course, be more inclusive in trying to integrate all who have been contributing throughout this last 16, 17 years of the court's existence. We wanted to launch here in The Hague at the ICC because President Fernandez, as I said, was actually the organizing meeting of the coalition in 1995. Her term will finish in a few weeks' time, and she also very much valued that our trying to bring together the leaders from the Rome process and actors in Rome, and was gracious to host our launch yesterday in the forum and the reception at the court. This is February, and this is Europe, where we're at, and therefore it was unrealistic to try, and we couldn't afford to try and bring participants from all over the world. But again, our goal is that we will end up having commemorations and stock-taking events, hopefully in every region and in every country, that we can convince governments and parliaments and others the importance of taking note of this anniversary. You will also have yesterday been given written statements and seen videos from, well, everyone from the former Secretary Generals and the current Secretary General and the President of the, or the Chairman of the Committee of the Whole, who became the first President of the ICC, Philip Kirsch. And I hope you will take those statements and comments into consideration as we proceed today with our 3 sessions. And we hope over this year that we will receive more statements, both video and written, from you and from others around the world on what their thoughts are about the status of the Rome Statute and the Rome Statute system after 20 years. And we asked the video presentations that you saw yesterday to do their presentations so that they could be used throughout 2018 at different events, and they will be available on the Coalition's websites and through our social media. And just briefly, the technical issues yesterday were just the incompatibility between some of our videos and the system at the court, but all of the videos are very usable, and we hope that you will take advantage of that. Again, the procedure that we were wanting to do in these 3 sessions today is to have presenters with relatively short statements open the session, and then hope that we can have participants at the forums contribute their own brief questions or statements or comments or challenges in the room, so that it is, instead of a few people raising many issues, we'll have many people each raising a few issues. And we hope also that this isn't just a commemoration of celebration, but that we want people to have serious, candid observations about the status of the Rome Statute, the status of the court, and the future of international justice. So with these opening remarks, and of course, if you will also take notice in the program, we want to thank the continuing supporters of the coalition that give grants and other support to the coalition, and we've listed some of the continuing ones, but of course we want to take note of the literally scores of other foundations and governments that have contributed over the last 20 years. Without that support, our coalition and the work of hundreds of our member organizations would not have been possible. So with that, let me invite our opening panel to please join me at the podium, and we will begin our presentations. First, we're pleased to have His Excellency Juan Antonio Yanez Buenuevo, the ambassador, retired, who was the head of the delegation of Spain at the Rome Conference, and deeply engaged in this system and work, and I think the ambassador will explain that, and we look forward to your first intervention on strengthening the Rome Statute.
Good morning, everybody. Please excuse the state of my voice due to a cold. And colleagues, friends, first of all, I would like to thank Bill Pace and his dedicated team at the Coalition for the International Criminal Court for not only for inviting me, but above all, for taking the initiative of holding this launching of a commemorative year. And I also thank you, all of you, for having come from many places around the world to join in this commemoration. But right from the beginning, I would like to say that we should not, I think, dwell too much on the past. Maybe just enough what is proper, but we should dwell above all on the present and the future for the court and for the overall system of international criminal justice in a globalizing world. But the theme of this first session inevitably is focused to a certain extent on what happened 20 years ago. Well, in my case, I must say that I was involved, actively involved, both in the creation of the two ad hoc tribunals for Yugoslavia and Rwanda, in the Security Council in 93 and 94, and then in the negotiations leading to the establishment of the ICC in Rome and after Rome. And let me just say that when the Security Council adopted its resolution creating the Yugoslavia Tribunal, it was my privilege to speak on behalf of Spain to say that that could only be a first step towards the establishment of a permanent jurisdiction with potential universal jurisdiction to deal with all situations or all crimes, grave crimes committed around the world. And that would be the International Criminal Court. So I was very privileged to have been present in the creation along those years. Now, that was really a great challenge, we all know. There have been many attempts in the past since the end of the Second World War, and those had failed. Why is that the effort that was done in the 90s could achieve its goals? I think it was to a large extent because of the end of the Cold War, precisely, and renewal of international cooperation at the UN and elsewhere, but also the shock caused by the Balkan Wars and the genocide in Rwanda, no doubt about that. And probably without the creation of the two ad hoc tribunals and several other mixed or hybrid tribunals, probably there would not have been sufficient political will to create this permanent and general court that we have now. But that was not enough in itself. There was also a need for a critical mass of states that would push the process forward, and that was the like-minded countries that were very active in the negotiations in New York, but then also in Rome and thereafter, from various parts of the world, middle powers and small countries as well, without the proactive position taken by the like-minded countries, probably other countries or group of countries would not have budged. But then also the coalition, the NGO coalition. Now I see that the words NGO are not in the official title, but at the time it was NGO coalition, and I want to pay tribute to the coalition and to many of its constitutive members for the action they had in pushing states, in bringing the debate to public opinion around the world. Also in parliaments, that was very, very important to have a pressure on, political pressure on governments, and also for the ratification of the statute and other instruments. And then the legislation, internal legislation. I think now about half of the states parties have modified their internal legislation to be able to invoke complementarity if the need arises, but also to facilitate cooperation with the court. That is extremely important. I will come back to that. So this, I think, suffices for the moment about the past, but the important thing is that for the first time ever, the international community, not just the 120 states that voted in favor of the statute, but also or the 123 that are now states parties, or the 138 that have signed the statute. The Rome Statute is not just another multilateral treaty. It is special for many reasons, but one of the reasons is that it represents the common will of the international community, not just the will of the countries that have signed or ratified. Because of the connection between the statute and the UN, it is really the creation of the whole of the international community, and it speaks to the whole of mankind. Now, we know that we are facing many problems now. We have gone very far in the work of establishing the court, having situations under its jurisdiction, having active cases before their chambers. But we also know that there are many obstacles, many difficulties. One can read analysis, stock takings, even by supporters of the court and sympathetic commentators that speak about lackluster performance or unfulfilled aspirations. Now, it's a work within the court and also among those who work for the success of the court to make things in a way that the court is a success, and not only the court in its own work, but also what is even more important, the wider international system of international criminal justice. Only last month, the court, under the leadership of President Fernández de Gurmendi and with the assistance of the European Union, held for the first time ever. I must say I was very surprised to read that it was the first time. I thought that things like that must have happened already, I don't know, 5 or 10 years ago. But the first global seminar with chief justices and judges from a variety of countries, states parties, but also regional courts, international courts, in order to work together towards the development of this global system of international criminal justice. Without that, the court is almost unable to fulfill the promise of the statute. So this interaction must continue and be strengthened and deepened. And ourselves, civil society, because now I'm retired, I'm no longer a government representative, I'm a member of civil society, we have to renew our purpose, our dedication, under the leadership of the coalition, it will be extremely important, I think, that this year, 20th anniversary year, is marked by a new alliance, a renewal and a renewed and strengthened alliance of the the like-minded states, or those states that are willing to go forward with the system of the Rome Statute, and civil society organizations. So I invite you to provide leadership for that. Thank you.
Thank you. I had forgot to introduce, because we do have participants today that were not with us yesterday, the three sessions. The first session this morning is on the historic significance of the Rome Statute, of the International Criminal Court, the adoption of the treaty, this is viewed from civil society, from national justice efforts, the work of the court. What were the factors in 98 to 2002 that supported the creation and the establishment of the ICC? Are those factors still there? What are the new factors and developments that have emerged? How does the Rome Statute exist within the framework of the ad hoc special tribunals and the wider post-Cold War international criminal justice system and justice systems? Has the statute successfully addressed the peace versus justice debate? And what are lessons learned from other jurisdictions that must be taken into account with the Rome Statute system? And we're very pleased that the ambassador has just addressed a few of those. Next, we would like to ask Kimberly Prost, who was with the Canadian delegation and whose history of participation in international justice, in the UN system, in accountability efforts has been extraordinary, and is now chef de cabinet to the president of the ICC, and was just elected in December to be a judge beginning in March here at the court. Kimberly.
Well, thanks very much, Bill, and may I add my thanks to the coalition for giving me the opportunity to participate today, but also a word of congratulations for a tremendous organizing of a tremendous launch of this important year of the 20th anniversary of the Rome Statute. So I am very appreciative of the opportunity to share some reflections on the ICC at 20 years, and Bill and Richard, for my own good, have protected me from dealing with the topic of cooperation, which is something I worked on extensively during the negotiations, because I probably would not be able to maintain a judicial decorum at all in speaking to that topic. So the point I wanted to put emphasis on, or my focus of my remarks, is on the ICC within its role within the international criminal justice framework, and basically what that means for the court today and what it means going forward. And there's two really features of the ICC that distinguish it, that make it significant in terms of the international criminal justice framework, and that, of course, is its permanent nature as an institution, and also the fact that it is premised on the principle of complementarity, and thus is part of a system designed to end impunity. And I think an important question for us to ask at 20 years is the ICC living up to its potential as an institution of that nature, and are we properly interpreting what the role of that institution should be in today's landscape? I think the first and obvious point on the question of living up to its potential is one that was mentioned many times yesterday. Of course, it can never properly fulfill its role as a permanent institution until it has universal adherence. And that is why the quest for universality has been and must remain going forward one of our most important goals for the ICC and the Rome Statute system, because it is essential to its effectiveness and credibility. But there were also, for the framers of the statute and the negotiators back in Rome and prior to it, there were also other reasons why the permanent nature of the institution was so important. And one of those is something that is already being debated, and that is the question that, the feeling that if we established a permanent institution, it would have a much more effective deterrent effect in terms of conflicts, in terms of the commission of these crimes, than the ad hoc institutions that came along during the midst of conflict. And I know that there is already criticism or discussion about whether the court and the system plays that role, but in my view, it's far too early. As we would say in the common law system, the jury is still out on this, because the most important in the long run, the most important way that this institution can serve in the deterrence context is if it is seen as a credible and relevant institution in the international criminal justice framework. And that is still a work in progress. And it is tied to the core mandate of the court, how it delivers justice in its cases, the efficiency, fairness of the proceedings, the jurisprudence, the quality of it, its adaptability to the crimes as we know them today. And that is why the work which is going on at the court, particularly by the judges the past few years, the focus on arriving at consistent practices, on efficiency, is so critically important. And I'm very much looking forward to joining my new-to-be colleagues in continuing those efforts. But I think we really have to give the court more time to work on that aspect. And the other goal of a permanent institution, of course, was the idea that we would replace and make it more efficient by having one permanent institution and not reinventing the wheel in each situation. And of course, that remains the case today. Our goal is one permanent, universal, international institute. But I think we, at times, misinterpret what that should mean. It, of course, should not mean that we do not have a need, an urgent need, for other types of ad hoc or permanent special courts, special chambers at the national and regional levels. That is not only not inconsistent with the system, but it's critical to the whole concept of complementarity and building a Rome Statute system. So even institutions like the IIIM, the Syria mechanism, is completely consistent because it's there to try and promote extraterritorial jurisdiction cases, all consistent with the Rome Statute system. And that brings me to the second area and the issue of complementarity. And one of the things that I don't think we envisaged and I'm pretty sure we didn't envisage back during the negotiations, was the tragic proliferation of situations that we see today that fall within the mandate of the court. And unfortunately, we now have this perception that the ICC, as a standalone institution, is supposed to be the solution for all of these situations. You see it in the press all the time. What is the court doing about this situation? And we have to recalibrate that perception, because it's not the court as a standalone system, it is the system as a whole. And on that, diplomacy has never been my strong suit, and so I figure there's no need to start today. So, being very blunt, we have not done well in promoting positive complementarity. We have not done well in building national capacity to investigate, to prosecute, and to cooperate. And we have to do far better, because the ICC has to be seen in the context of a system in order to meet the expectations of victims and to bring an end to impunity. And on this issue, again, being very blunt, it's been made very clear that the court should not lead on positive complementarity, on building national capacity, and I agree entirely. We do not have the time, resources, or mandate. But that shouldn't mean that no one's leading on this topic. And there has been tremendous work. It's not just because we're here with the CICC, tremendous work by NGOs. I always mention Parliamentarians for Global Action, who've done a tremendous job on capacity building implementation legislation. But the spirit of Kampala needs to be rejuvenated, not this time on the crime of aggression, because we're there, but on what was said about complementarity. States must lead, along with intergovernmental organizations, NGOs, civil society, and the court, of course, in carrying out the capacity building. And just some questions I throw out on that point. What happened to the idea, the important idea from Kampala of having a system of matching needs to programs? What about using the ASPs more effectively for practical work on national capacity building and implementation? What about the facilitations? Can we make them more of a practical work forum? And I also have a question that's not directed at states. I've been asking this ad nauseum, probably to myself most of the time, but where is the United Nations Office on Drugs and Crime in building capacity to deal with the most serious crimes? Why is that not top on the agenda of the UN's crime body? And I used to work there, so I feel I can say that. I'm going to come to an end. I can feel Bill sort of eyes boring into my neck, but I just want to emphasize that the point is for the ICC to properly play the role that it has within the institutional criminal justice framework, we must continue to strengthen the court as an institution in terms of its core functions, but we must also work very hard and renew our efforts to build a robust Rome Statute system. Thank you.
Thank you very much. And again, I think now Judge Prost is presenting some excellent answers to some of the questions that we hope again to hear some of your either comments or questions or about it. And clearly, I think the issue of the role of the UN, but also I think the primary role of the Assembly of State Parties in complementarity, in positive complementarity, that is one of the most important challenges I think the coalition members have felt has to occur. And this also includes the issues of cooperation. Next, we have, who was then a young diplomat, delegate, legal advisor from Argentina in Rome, and also was one of the first employees of the new court and the office of the prosecutor, Fabrizia Garaglia, director of the prosecution divisions of the International Criminal Court. Fabrizia.
I was going to thank Bill for the presentation, but it breaks my heart that after 20 years he can't get my name right. I think that one important thing is, having been in Rome, I know for a fact that there will be no ICC without the CICC. There will be no ICC without the massive push from civil society and the outstanding work done by the coalition under Bill's leadership. And it should come as no surprise that it is the CICC that 20 years later provides this forum for us to celebrate what has to be celebrated, but also to think critically about what has been done and to discuss what we can do all better in the future. And what I'm going to try to go through very quickly some of the main lessons learned that we can take from the first 15 years, but also from the previous experience from the ICT1 and the ICTR. What was taken on board by the ICC, what wasn't, and with particular emphasis on the Office of the Prosecutor, which is where I work. So when the ICC started its operations, there was already a significant amount of best practices being identified by the ad hoc tribunals and to some extent by the Special Court of Sierra Leone. And that was a big difference with the ad hocs, right? When the ad hoc started, there was nothing except Nuremberg in a very distant past. So this was a golden opportunity for the Office of the Prosecutor. And the question is, did we use it effectively? And the answer is a mixed one. At times we did, at times we didn't, at times we decided to learn the hard way. At times we took some lessons, but we forgot that there was a second part of the story. And let's go quickly to some of them. One was a critical lesson from the ad hoc tribunals, something the ad hoc tribunals didn't do well. and that was avoiding legal chauvinism. In a fantastic presentation on Wednesday in the Grocery Center, President Fernandez was reminding us of the importance of avoiding legal chauvinism and dominant legal cultures in the context of international criminal justice. So the international criminal practitioner has to really leave at home the luggage that he or she carries in terms of how you do things locally and has to think globally. In the ICTY OTP, where I had the honor to serve for 5 years, this wasn't really the case. There was a dominant legal culture. There was a common law domination of the Office of the Prosecutor, which was consistent with the adversarial matrix, the pure adversarial matrix of the ICTY statute. But that, which was not fatal to the operation of the ICTY was a success story, but in terms of perception of legitimacy, in terms of universality, it did not go well. And this was a lesson that we did take, and I think that basically from the beginning we placed emphasis on geographical balance, avoiding a dominant legal culture, and promoting an internal exercise of legal cross-fertilization. And today I can say with a lot of happiness that the civil law lawyers in my division are emphatic supporters of the adversarial elements of the Rome Statute and the rules, and in turn the common law lawyers are more civil law than the civil law lawyers when it comes to the civil law elements of the statute and the rules. So in that sense, that is one that we can check to say there was a lesson that we did learn, and we did learn fairly well. One that was learned but not sufficiently well was the critical importance of witness protection in international criminal prosecutions and investigations. Again, the ICTY had a mixed record in a way. It had provided excellent witness protection, and it was a success story when it came to witness protection of the crimes committed in the Balkans. And it was helped by some specific circumstances, such as the zones of natural protection that were created as a result of the demographic redistribution of the population after the Dayton agreements. It did fail, however, when it had to deal with the Kosovo crimes, and the KLA being an active group capable of causing harm to victims and witnesses and causing harm to victims and witnesses. And that was, for instance, the big failure of the Limay case, which is one that we were acutely aware of, and one case that we hammered through in the Office of the Prosecutor of the ICC over and over again. Also in our discussions with the registrar and chambers, so we kept saying, Limay case, we need to learn this lesson. And yet, when we were faced with a massive campaign of witness interference in the Ruto case, involving the Kenya situation, it became crystal clear that we had not taken the full lesson on board. It became crystal clear that our assessment had been partial. It became clear that we didn't have a clear strategy of protection. It became clear that the campaign of interference was really too much for the trial chamber to handle. It became clear that the institution as a whole was not prepared to deal with a threat of this level. And we know what happened in that case. The good news is that since then, a lot has been done. I think there's been a learning curve for the institution as a whole, certainly for us, certainly for the victims and witness section, but also for the judges who have now basically become aware of the problem that witness interference can derail a case and have taken steps to prevent this from happening. So in contrast with the Ruto case, in the Netaganda case, a similar effort to try to derail the case by means of witness interference and witness coaching was tackled in time by the Office of the Prosecutor, by the Victims and Witness Section, and by the Chamber, who had no problem in taking very harsh measures to make sure that that conduct did not bear fruit. So in that sense, a lesson that has finally been taken, a bit late perhaps, but still one positive element. There was one lesson that was disregarded initially, unfortunately, by the Office of the Prosecutor, and then we learned the hard way. And that is the importance of making sure that by the time you move forward, your case is ready to go to trial. You already had that in the ICTY, was clear. You read the ICTY best practice manual. It says, ideally, a case should be ready for trial before an indictment is issued, and it should be the object of the prosecutor's investigation to gather all necessary evidence before any charges are brought. Now, this requires carrying a proper, in-depth investigation, collecting all the evidence that you need, and not rushing unnecessarily to present a case just for the sake of presenting a case, or to look that you are really just doing stuff and that you are a success story. Unfortunately, our initial policy of focus investigations led to rush cases and to very bad results in court, which continue to haunt us to some extent until today, even though that we have completely changed policy, and have dented the image of the court. And we are acutely aware of this. That's why in 2012, we issued a new strategic plan, and we shifted completely our policy in relation to investigations and prosecutions. We adopted a model of open, in-depth investigations. We delved into alternative ways of presenting cases. We started exploiting forensic and scientific evidence in a way that we had never done before. We started experimenting with new technological innovations and how they could be effectively used in investigations and prosecutions. And critically, we committed ourselves and to the world and to the judges that we would be always ready for trial at the time of the confirmation of charges, so that we would always present cases that were in a state of trial readiness or very close to a state of trial readiness. So again, one lesson that was learned a bit late in the day, but at least it was learned at some point. Now, let's go to the sort of dark side of the experience of the past 15 years. One lesson that has not been learned, not only by the ICC, but I would say by the system of international justice created by the ICC as a whole, and that is the critical importance of arrest, which sounds like an obvious thing to say, but doesn't seem to sink in in a number of ways. In the ICTY, and the ICTR scheme, the success of the ICTY and the ICTR, by and large, is predicated on the fact that they have managed to complete their prosecutorial programs. In the ICTY, all indictees have been arrested and prosecuted. In the ICTR, I think there is one at large or two. A minority, three. Okay, great, so, thank you. Three of them, which is still a minority of the totality of the cases. Now, we have an enormous amount of outstanding warrants of arrest. In the ICTY and the ICTR, the institutions decided to become proactive in terms of making sure that they would try to get arrests happening. But that alone is not sufficient. States decided to play ball. States decided to run the extra mile and to do what had to be done, including putting political pressure, including making, for instance, membership to the European Union of the Balkan states conditional on effectively arresting the fugitives that had not been arrested. And unfortunately, we have nothing of that in the ICC. The institution has been largely reactive when it comes to arrest opportunities. We have not been proactive, and that's a conversation that we're starting now within the Office of the Prosecutor, but also with Registry, and I assume we'll have it as well with Chambers during litigation, how we can become more proactive in ensuring that there are effective arrest opportunities. But that alone is not going to take us anywhere. We can be as proactive as we want, but if there's no one willing to implement a warrant of arrest and to do what it takes to make sure that someone that has been the subject of an international arrest warrant by the ICC is effectively brought to justice, then the system can succeed. And today, as you know, we have, for instance, President Bashir traveling to a territory of state parties with little or no consequence whatsoever. I don't think one has to be a genius to see how damaging this is for the credibility of the system of international criminal justice, for the promise of justice that the ICC statute and the ICC brings to victims of these crimes, and to the success, ultimately, of the whole exercise. So this is a lesson that, basically has still not been learned, not only by us, but also by our partners, and one that is critical that we all learn if we're going to succeed in the struggle against impunity. Thank you so much.
And again, I think it's important to point out that the court doesn't do arrests, that the arrests have to be done by state parties or governments and transferred to the ICC. And the coalition, of course, also has been fervently striving to raise this issue with the governments. It also, on the two ad hocs, for example, you had them and others under Chapter 7 of the Security Council, the power of the Charter. They were single situation, basically, issues, and we have seen the Security Council fail in so many ways in maintaining international peace and security. And I think that is going to add additional responsibility for complementarity for the Rome Statute system, et cetera. And our final presenter in the opening session here today is a real leader from Africa in international justice in the recent years. And we're fortunate that Evelyn resides in the Netherlands, and her excellent organization, which is focused on Africa, she is able to be guided from here and the continent, and we're very pleased that she's agreed to provide one of the opening presentations. Evelyn Nkuma, the Executive Director of African Legal Aid.
Excellencies, dear colleagues and friends, first of all, I'd like to thank Bill Pace and the CICC for convening this important forum. I couldn't agree more that the 20th anniversary of the Rome Statute of the International Criminal Court should be celebrated. There are benefits to celebrating anniversaries and milestones, too many to list here. The 20th anniversary of the Rome Statute is an occasion for reflection. Indeed, this forum is to consider what lessons can be learned from the experiences so far, and to explore how the criminal justice system set in place by the Rome Statute can be improved. Yes, we have reason to celebrate. The impossible has been made possible. The court has actually been created. It is now fully functioning, and various cases have been completed. The crime of aggression, a leadership crime, is now part of the Rome Statute. At the same time, we have to be honest and realistic. The Rome Statute system has not yet matured into a fully effective criminal justice system from which no perpetrator of international crimes can escape. Too many countries, including the politically most powerful, are not party to the ICC statute. There are even states that have stepped out, served their notice to step out, and unsigned. The Office of the Prosecutor faces practical and political obstacles in its efforts to gather evidence, particularly in cases concerning politically powerful individuals. We all know the accusations of selectivity and the critique that the ICC is not being sufficiently effective. Trials that take too long to start and too slow to conclude, while the accused remain behind bars, giving rise to perceptions of injustice. A lot of work still needs to be done. Yet, what exactly should be done? Not too long ago, a friend asked me, is there a future for the ICC? Is it not much better to put all our efforts in ad hoc or special tribunals, such as the Nuremberg Tribunal, the Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda, the Special Court for Sierra Leone, the extraordinary African chambers within the courts of Senegal that successfully prosecuted Hissène Habré? I understand my friend's question. The ad hoc or special tribunals have proven to be quite effective, but to ensure international criminal justice in the long term, we cannot depend on ad hoc tribunals alone. We simply cannot create new judicial bodies in response to each conflict in which atrocities occur. It is too costly, too cumbersome, and there is no guarantee that ad hoc tribunals will actually be set up to address specific situations. We need a permanent body to fill gaps in the international criminal justice system. We need the ICC. The same is true for national criminal justice systems. Of course, national and regional systems have the advantage of doing justice at home or close to home, and therefore have greater legitimacy than an international system. Yet, the entire international criminal justice movement was born precisely because national criminal systems often are either unwilling or unable to perform. We need the ICC. The question remains how the entire Rome system can be improved. We can draw inspiration from Nuremberg, Yugoslavia, and Rwanda tribunals, but should realize that they were one-sided initiatives. Those tribunals were set in place to prosecute situations that had already arisen, and the states involved in their establishment knew that their own nationals and allies would not be brought before those tribunals. Commitment to the ICC statute, however, requires from states something far more fundamental. It requires from states the willingness to accept that their own nationals, their own leaders, might be prosecuted. This requires a partial surrender of national sovereignty. We must recognize that the ICC, for the years to come, will have to function in a politicized setting in which cooperation from states is not guaranteed. The 20 years ahead will not necessarily be easier than the first 20 years. Yet, in the first 20 years, the foundations were laid for a system that has the potential to promote international criminal justice. We must continue to build and develop the system that was created in Rome 20 years ago. Thank you.
So now is our test on whether this is going to work, and I'm fortunately seeing a few hands and participants who are willing to raise some issues or make comments on issues, etc. But first, we're going to have Judge Politi do the first comment. Mauro Politi was a legal advisor at the UN, a key leader in the process in Rome, and one of the first judges elected to the International Criminal Court. And I think we'll use either these microphones or handheld, and you can let us know. And again, if some of you would let me know by your hands if you're willing to make an intervention.
Thank you, Bill. It's a pleasure to be here. I would like to thank you so much in the coalition for this opportunity, and thank obviously the president of the ICC and the ICC for the celebration of yesterday. I'll try to avoid to fall into the trap of nostalgia, but there is one point that I want to make at the beginning. The memory of what happened in Rome 20 years ago, the memory of the process that led to the creation of the ICC is indispensable in order to assess and imagine what the court should be in the future. We should not accept, when we discuss successes and shortcomings of the court, we should not accept any lesser standard than that. We should have in mind what were the dreams, what were the expectations in the process that led to the Rome Statute, including the emotions and the final liberations that in the movie that was has been played for a long time now, and I almost don't know every little piece of that. But we should not accept a lesser standard. We should not say, oh, the situation has changed, so we don't want it. We can accept something less than what we imagine in Rome. No, we have to have that clearly in our mind. In 2008, we celebrated the 10th anniversary of the Rome Statute. I was in the court at that time. The court had started to work. We had the first confirmation decision. Arrest warrants had been issued, in some cases executed. Proceedings were ongoing in various situations. But the court remained at that time at the pioneering stage. We really didn't know what to say about whether the court had achieved its mandate. But now we are in a different situation. The court is still a teenager, I would say, but it has had a vast experience and a vast jurisprudence that would allow us, I think, to start to make an assessment of what it is. The court has been also has gone through an important process of dialogue and sometimes of confrontation with states parties. We can make a first assessment of where the court stays and what are the challenges ahead. One thing is clear. It has been underlined already by various speakers, that the court is here to stay, that the court is accepted as a universal, not a universal, but an institution that is fundamental for the fight against impunity, that has the that is there to conduct a fight against impunity that has not been defeated worldwide. Without the court, the impunity would be absolutely out of control, and this has to be very clear in our mind. Obviously, the court has to fight still to become even more credible and more relevant, as Kimberly Prost has underlined. But we are confident that it's going to be there to respond to the request and the demand for justice that come from states, but comes also from the world civil society. Does everything correspond now to the dreams of the framers of the statute? Probably not. There are problems. Too often, as been remembered now, cooperation is still lacking. Proceedings against state leaders in office remain problematic. The prospect for key members of the international community to join the Rome Statute seem to decrease rather than improve, and the tensions with some regions have not been completely diffused. These are problems that need to be faced, and there is a real risk for the court today, which is to suffer the consequences of a perceivable loosening in some states of the sense of respect of the rule of law and trust in multilateralism. The atmosphere is not the same as it was 20 years ago. 20 years ago, the idea of international cooperation, respect for the rule of law, trust in multilateralism was very, very high. I remember in 1995 we had the Congress of International Law, and Scorell, I remember that, when we were talking about international law as a language of international relations, and it was a triumphant moment for multilateralism that didn't last very long, actually. Many states at that point, they started to be extra courageous to embark into the project of the ICC. That didn't last very long. And I remember in Rome, we were discussing at some point when we were not sure that we could make it in having the statute. I remember that we were started to talk about having another conference 1 or 2 years later. It wouldn't have happened at that point. If we had waited 2 years, it wouldn't have happened. The climate rapidly has changed. Now, what would the court should do now in a situation that is different? Again, credible, efficient, relevant, responding to the query for justice that comes from the world civil society, that comes from the victims. Now, successes, shortcomings, I don't want to dwell in this short intervention. Maybe I will say something in early afternoon today. There are challenges that were not foreseen in my view, and there are successes that are not duly underlined, but I will say that later on. One last comment is on peace versus justice. Given the types of situations that the court is facing, it's inevitable that the question of crime and of peace versus justice will arise. And I remember when I started to work at the ICC in concrete cases and concrete situations, without naming anyone or any situations, the suggestions started to come to the court to please take into account the political situation and the political environment, suggestions to be cautious, to be attentive. It is, as I said, inevitable. I want to make 1 or 2 points on this. There is only one way to respond to that. Peace cannot be achieved at the expenses of retributions for the major perpetrators of international crimes. And this has to be, in my view, the leading principle that the court should follow. And obviously there are other collateral issues, the immunity of state officials, and I think the court has responded well to the main principles of in this area. The question of the Security Council, how the Security Council follows up, for instance, to referrals by the court. In general, the capacity of the Security Council to respond to situations that would need to be sent to the court. Now, I mean, I think that the court on this last point is doing what it can, both in chambers, in terms of activity of the chambers and activity of the prosecutor. Prosecutor goes to the Security Council every few months and tell them, what are you doing? please do something about follow-up on the referrals. My last comment on this is probably what needs to be studied and maybe regulated is the relationship between the Rome Statute system and the transitional justice system. It's not clearly regulated, it's not clearly established by the statute, and I think that a lot of work should be done in that area. Thank you.
Thank you very much, and I think we could have an entire conference on the very last point on the relationship between the Rome Statute system and the transitional justice system. But I do want to emphasize one issue that a number have raised, and that is, could the Rome Statute, if it hadn't been agreed to in July of 1998 at the end of the first session, would it exist today? And if it wouldn't exist today, I think it's very certain you could say that many of the most important elements or strengths of the statute we know clearly would not succeed in the international community negotiations today, whether it's independent court, independent judges, independent prosecutors, proprio motu, the gender crimes, the rights of victims, no reservations, no immunity for anyone. All of these, I think, would be under jeopardy today. So please, and also if we can get participants to introduce themselves and make their presentations. And then Thomas and then Drew. So we have 3 or 4, and I hope others will be. Very good.
Thank you. Thank you. I have just a quick question, and my name is Vladimir Rudnitsky. I was in the drafting committee in the Secretariat at the Rome Conference and Credentials Committee, Secretary for Spanish, the 6th committee dealing with that issue as well. I have a quick question to our first speaker. Basically, Excellency, as you remember yesterday, the issue of the correlation between the Security Council and the International Criminal Court was raised, and today mentioned as well. And many would agree that in current situation, any radical reform of the Security Council is unlikely to happen in the nearest future. So my question is, do you have any practical suggestions on how to improve the interaction between the Security Council and the ICC in current political situation? Because this issue still has to be addressed somehow, no matter how serious or difficult or complex the situation may be. But it's a practical issue, so I would appreciate knowing your opinions. And we discussed a couple of things yesterday, but if you would share with us your views, I would appreciate it. Thank you.
Thank you. Thank you for your question. Of course, the relationship between the court and the Security Council is extremely important, particularly for situations elsewhere from the states parties. There are until now 2 occasions in which the Security Council has referred a situation to the ICC, first in Darfur and then in Libya, which I must say at a given moment would have been thought almost unthinkable in the climate. It was not clear whether all the permanent members would agree to that. But it happened. In one case, I think the United States abstained, but then let it pass. But my main concern has been that the Council has not been consistent in supporting the court and its work on those cases, on those situations that had been referred by the Council. I think it's an exercise in irresponsibility. If the Council, for whatever reasons, thinks that the situation is appropriate to be sent to the court, it should be also convinced of its responsibility to a continuing support of the action of the court in that given situation, in that given case. This has not been the case, neither in Darfur nor in Libya, as we all know. What I could say about practical ideas, it's not a question of practical ideas, it's a question of political will. And we can invent ways. As you know, the prosecutor, the ICC prosecutor, address the Council every now and then, 6 months or so. And then she is politely heard, and then nothing happens, more or less. The other way in which the Council is involved in relation to the court is on the other aspect, Article 16. The Council can stop a given proceedings in the court if it feels that the continuation of those proceedings may be damaging to international peace and security. Well, fortunately enough, that I know there has been one attempt to invoke Article 16 in the Council. Unfortunately enough, there were enough members in the Security Council to stop that attempt to stopping the court. So no action was taken, mainly because of states parties or the Rome Statute being present in the Security Council, but even some non-state party joining them in stopping that damaging course of action. But I don't think really what more could be done. Certainly it is very important that the states parties present in New York, not just in the Security Council, but the like-minded countries remain very alert, very actively engaged with members of the Council. I know that this has been the case. For instance, Christian Veneveza has been very active, as was Prince Zayed before, when he was president of the Assembly of States Parties, in order to gather support, in order to defend the court each time before the Council. But I don't know what more could be done. And also, we shouldn't forget the role of the Secretary General of the United Nations. Certainly all, since Kofi Annan, we heard yesterday, but also his successors, and now Secretary General Antonio Guterres, I'm sure that they are also very sensitive and intervene politically in order to defend the court. But they have not been able, in the proactive sense of convincing the Security Council to be more supportive of the action of the ICC in those situations sent by the Security Council. Thank you.
Kimberly, did you want to say something?
Just very briefly, speaking from my capacity when I was the ombudsperson for the Al-Qaeda Sanctions Committee, and one of the arguments that I think, I'm not at all convinced it would be successful, but I really think it's helpful, as I did with sanctions and fair process, to argue that it's not about the International Criminal Court. It's not about whether you support the court or you don't support. It's about the fundamental credibility of the Security Council. Because why should they expect that states will respond to Security Council resolutions and Chapter 7 action when the Security Council itself does nothing to enforce a resolution that they adopted under Chapter 7. What does that say about their actions in other areas? And I think that as an argument that at least has some potential of getting them to think beyond their obsession of certain members against the ICC. So I just throw that out into the mix.
Thank you. I guess, Thomas, and again, if you would introduce yourself, or if you want a handheld mic, let us know, but otherwise. And then we'll have you and our colleague from...
My name is Thomas Verfuss. I am the president of the Association of Journalists at the ICC. The AJICC was founded in 2002 by journalists of leading news organizations like the New York Times and Agence France Presse, who covered the ICTY and the ICC, which was in the process of being set up. Thanks, Bill, for organizing this event, and thanks for organizing the lessons learned question in your introduction. In fact, the lessons learned question was on everybody's mind and lips 15 years ago, when a similar audience organized on this very spot in still the old Academy building during a public hearing which Luis Moreno Ocampo organized after he had taken his oath of office here in the Peace Palace. During that seminar, the AJICC looked back at the situation of the press in the former Yugoslavia and at what it meant for the coverage of the ICTY. And we recalled that the ICTY in its early years had a serious public relations and publicity problem. The ICTY was not understood in the former Yugoslavia. The new countries on the territory of the former Yugoslavia were not models of democracy and free press. There was lots of propaganda. In Serbia, the state media described the ICTY as a NATO tribunal. In Croatia, the ICTY was described as a court that did not understand that Croatia had to defend itself against Serb aggression, and that the Croatian indictees were in fact heroes of the big patriotic war Croatia had to fight. Embassies of Western countries saw that problem of misunderstanding of the ICTY in the press of the countries concerned, and schemes were set up to help journalists from the former Yugoslavia who endeavored to report about the ICTY professionally, which is independently, impartially, neutrally. A news agency was set up thence by such journalists from Serbia, Croatia, and Bosnia. That news agency was supported by states like the Netherlands, the United Kingdom, Germany, Luxembourg. It was supported by intergovernmental organizations like the European Union. It was supported by foundations. And that way, all proceedings of the ICTY were covered by a group of journalists from different countries of former Yugoslavia that would produce coverage that was so neutral and impartial that it would be publishable in all countries of the former Yugoslavia. And that system was in place for a couple of years. It was a good system. The problem had been that it took countries a few years to realize that such a system was needed if states didn't want to leave reporting about the ICTY to the propaganda journalists. I raised this issue 15 years ago on this very spot before a similar audience of diplomats, judges, lawyers, NGO representatives. There was not only the usual polite applause after my intervention. Diplomats also came to see me during the coffee break, and they said, it's a bad thing that at the ICTY it took many years before such a thing as SENS was set up. At the ICC, we'll make sure that as soon the first trials start, something like that will be there as of the beginning. If we look at the situation now, 15 years into the operations of the ICC, we have 3 ongoing trials about Uganda, about Congo, about Ivory Coast. If you look at the public gallery, you will see no journalists from those countries. They can't come here, they can't afford it. Before the start of the Ntaganda trial, I received an email from a group of journalists from Eastern Congo who said, we are local radio journalists from the region where the alleged crimes have been committed. We asked our village leaders if they could send us to The Hague because we want to report about the Ntaganda trial, because that is they are about victims that are part of our local population. Our village leaders said, we have no money. So we wrote to the court if they could organize paid internships for us to be there. The court does not have that possibility, so they could not come. In fact, the 3 ongoing trials are ongoing with the conspicuous absence of the press of the countries concerned. The only exception was Kenya, the Kenya situation when it was active. The Kenya press could afford to come here, but when we look at all the other countries, the local press does not have the means. Christian Wennerweser, when he was ASP president, put forward the idea of a 3rd trust fund next to the trust fund for victims and the trust fund for family visits, namely a trust fund for journalists, which has never made it to the agenda of the ASP, unfortunately. I raised the issue with the new president of the ASP, who has ICTY experience as a judge and may see how valuable SENS has been. But looking at the current situation, we must unfortunately note that the promises made on this very spot in 2003 have not been fulfilled by the community of states, intergovernmental organizations, foundations and civil society that support the Rome Statute system.
Thank you, Thomas. Yes. Hopefully they will be meeting you at the coffee break today.
Many thanks for this opportunity to speak and to make some comments.
You need to hold the mic closer, please.
Okay. Okay. Sorry. The circumstances, the current circumstances are very different from those in 1998. I am the Director of Legal Affairs of Chile, the Ministry of Foreign Affairs of Chile, and I was part of the Chilean delegation to the Rome Conference at that time. Unfortunately, the circumstances, the current circumstances are very different. I think it was reinforced now the ancient discourse of national sovereignty, and I think it's very important to join the effort between us in favor of the global justice. All of our delegation in 1998 were in favor of the global justice. We were part of the like-minded countries. So I think we can work together in a new impulse of the global justice. And I think it's very important to promote the positive complementarity, because all our countries has a judicial system and national courts, and in this level is many magistrates and judges, they don't know very well the system of Rome, the ICC system, and it's necessary to promote the cooperation between the national level and the international level. And positive complementarity is absolutely key. And the second comment is concentrated in cooperation. Cooperation is very key also in this process. And we need more interaction between the global level and the domestic level in order to promote the cooperation with the ICC. So only these two issues I would like to stress this morning.
Thank you very much. Our colleague here, yes, and then we have Hans and Mariana, and
forgive me, I will speak in French. Je suis Eugène Bakama, président du Club des Amis du droit du Congo. Je voudrais faire 3 petits commentaires. Le premier, en lisant le programme de la journée, j'étais un peu déçu de voir qu'il y avait une question essentielle qui n'a pas été reprise, c'est la question de la prévention des crimes. Vous savez que la Cour pénale internationale n'a pas été créée simplement pour réprimer des crimes, mais c'est aussi pour contribuer à la prévention. Et j'étais heureux de voir que Mme Kimberly avait souligné un peu quelques éléments par rapport à la dissuasion, mais elle a souligné qu'il faudrait plus de temps. Et là, je ne partage pas ces points de vue en disant qu'après 20 ans, je pense qu'il est important de faire le bilan de la Cour par rapport à cette question de la prévention, qui est une question qui n'est pas reprise souvent dans les discussions quand on parle de la CPI. Le deuxième commentaire, c'est par rapport à la présentation de Fabricio. Vous avez parlé de la rencontre entre des cultures juridiques, notamment le common law et le civil law. Mais moi, j'ai l'impression que le common law domine au niveau de la Cour pénale internationale et que cette rencontre n'a pas été que bénéfique pour la Cour, mais il y a des problèmes qu'il faudrait souligner et que peut-être qu'il faudrait revoir un peu pour qu'il y ait un équilibre entre les deux systèmes au niveau de la Cour pénale internationale. Et mon troisième commentaire, c'est par rapport au bilan. Vous savez que l'avènement de la Cour a mis en place des systèmes à 2 têtes. Il y a le système de la CPI qui fonctionne très bien, mais il y a qui fonctionne très bien, mais avec des problèmes, comme on le sait, avec beaucoup de moyens, et les systèmes au niveau national qui ne fonctionnent pas dans certains pays, et il faut une réflexion par rapport à cette question. Et en dernier lieu, je dois dire que je pense que la Cour a besoin du sang nouveau. Il faudrait qu'on réfléchisse pour voir comment on peut améliorer le système de Rome. Merci beaucoup.
Merci beaucoup. Oh, no, go ahead. Okay.
Merci pour ta question. I'm going to respond in English. I mean, my passive French is okay, but you don't want to hear my active French. But if I can touch briefly on the issue of common law versus civil law, I think one thing that I always found a bit different is, in the same way that I have been telling for a number of years already, I have been working as an international prosecutor for over 20 years now. Yeah, around that, 18. I keep telling my common law friends, listen, a hybrid system is not a pure adversarial system with a presiding judge speaking in English with a funny accent. It has to be something else. In the same way, I have to tell at times my civil law colleagues, listen, the fact that you have one adversarial trial or a trial that has adversarial elements doesn't mean that it's a common law system. So we all need to get out of the blinkers and start looking at the system more holistically. The statute is full of elements borrowed from the civil law tradition, starting with the very position of the prosecutor, not as a partisan organ, but as an organ guided by the principle of objectivity, which has to investigate incriminating and exonerating circumstances equally. I can even appeal on behalf of the convicted person. So that comes straight from the civil law tradition. Victim representation comes straight from the civil law tradition. The powers of the pretrial chamber, including the powers under Article 56, come straight from the civil law tradition that are known to the common law tradition. The confirmation process, the way it's tailored, comes again from the civil law tradition. The fact that we, Office of the Prosecutor, are the same ones that also investigate and prosecute offenses, cases of offenses against administration of justice also comes from the civil law tradition. We have no contempt in the common law sense where we give it to an amicus, or we do it ourselves. There is a lot of that. So I have to say I resist that criticism that I heard a couple of times that there is an imbalance. There is no imbalance. It's a carefully drafted instrument, and it operates as such. For instance, we have now trial chambers using an approach to admissibility of evidence in trials, which comes straight from the civil law tradition itself. So the court, what it's doing, and I think that is something that we all have to celebrate, is looking at what works best from each tradition that is consistent with the statute and that promotes efficiency and fairness of the proceedings. And when it works, it doesn't really matter where it comes from. Legal chauvinism is the worst enemy of international criminal justice. It's the worst enemy. I have to say it, I will keep saying this until I die. If you want to have an efficient, workable, fair system of international criminal justice, forget where you come from. Forget the legal wars. Forget your legal culture. Make sure that what you have is efficient, is fair, it serves the interest of the exercise, which is too important to get lost in petty wars as to which system is nicer.
Thank you. Hans Corell. Then I have Felicity Wong, Mariana, and Matt. Okay, we'll get through all of them.
Thank you, Hans Corell. I was the legal counsel in Rome of the United Nations, and I was Kofi Annan's special representative in Rome. I was very glad to hear the discussion on the relationship between the ICC and the Security Council. This is precisely what I meant yesterday in my brief reflections, although I had only these few minutes to talk about it. Now, there has been reference to the rule of law. And I cannot say, but when I look at any conflict around the world, past and present, and ask the question, why is there a conflict? I come to the same conclusion. There is no democracy, there is no rule of law. This is why I spent my days since I retired from public service in 2004 to work for the rule of law. And there are 4 elements here I would like to stress in the rule of law by definition. Number 1, democracy, because that is necessary for a second element, proper legislation that reflects also international obligations, in particular in the field of human rights. And to be proper, the legislation has to be legislated in a democracy where the legislative assembly is elected by the people in the country. And then the third element is the institutions to administer this legislation, including independent and impartial courts. And then I come to the fourth, the most difficult perhaps of them all, the persons with the integrity and the knowledge to administer these institutions, including independent and impartial judges. And this is something that you don't build overnight. And I'll come back to this a little later, but I'm grateful. I am a judge by profession. I was brought up in the Swedish judiciary. As a young law clerk, I started back in 1962, and I served for 10 years in the court and ended up as a judge of appeal. And that was a tremendous asset for me, in particular during my time as legal counsel of the United Nations, and including working for the establishment of the International Criminal Courts. I was involved in all of them, Yugoslavia, Rwanda, Sierra Leone. The one I was not involved in was the one in Lebanon that was after I left the UN. So in the rule of law system, you have simply to have a functioning criminal justice system. And the rule of law has to apply also at the international level. And it is against this background that I see the International Criminal Court as an absolute necessity for the future. Otherwise, we will not be able to administer the world in a manner that people can live in dignity and with their human rights preserved. This is why it's so important that the work on supporting the ICC continues. And the CICC certainly has a role to play also in the future. And I really congratulate you on what you have contributed here, as I said yesterday. including these sessions. I also noted that Kimberly Prost talked about we need also other institutions. And I think this is a necessity. When I assisted Kofi Annan in Kenya, when he was chairing the panel of eminent African personalities who assisted Kenya in the national dialogue and reconciliation after the disastrous election back in 2007, I was involved in establishing the law that governed the coalition government that was formed after his efforts. And during that process, I had long discussions with the ministers of justice, both Martha Karua, but certainly Mutula Kilonzo, on how do we deal with those who orchestrated the violence in connection with the election in 2007. And when I had my last conversation with Mutula Kilonzo, he said, yes, only a few can be brought to justice before the ICC. We have to deal with the others ourselves. And his idea was to have the High Court dealing with those cases, because on that court, as often in the Commonwealth system, you could have judges from other countries. So you can be a judge in Kenya without being a citizen of Kenya. Otherwise, if you are a state official, you have to be a citizen of Kenya. But as a judge, you can come from another Commonwealth country. That was Mutula's idea. Regretfully, he was found dead under mysterious circumstances in his summer house a few years ago. And I still don't know why he suffered this destiny. But this is very interesting. And in a few days' time, the Soros Foundations will publish a handbook where they have analyzed 33 different situations over time here and drawn conclusions. And this handbook is designed for those who are asked to see what kind of institution can be established here to assist the ICC or to be complementary to the ICC at the national level. And often in these situations, the national justice system may not work well enough. And then you have to have a hybrid court or some institution, international or national. And this handbook I read with great interest, and I've been asked to write a foreword to it. And it's really a list, very practical list of questions. These are the questions you should ask if you are asked to do this kind of work. These are the elements you should look at. These are the things you should think of before you decide what approach to take in creating these institutions. And I see this as a further, shall we say, development of the interaction between the International Criminal Court and systems to create the additional justice that the ICC is not designed to deliver, because the ICC can only deal with it at the highest level. So I found that remark by Kimberly Prost very interesting. Also, there will be a book published in April by the founding prosecutors of the ICTY, ICTR, Sierra Leone, and Cambodia, and the International Criminal Court. And it's David Crane who is the editor of that volume. So this will be very interesting. Kofi Annan has written the foreword, and I have written an introduction to the book. Then we have to have effective arrests. And this is precisely what I meant in so many words yesterday when I referred to the Security Council. And of course, the situation in Sudan is an obvious thing. And then finally, the complementarity principle. I think that this principle, of course, is something that is so important that it cannot be stressed enough. At the same time, with my background in the judiciary, I know that you don't create courts overnight in a state which has not seen a proper justice system delivered. And therefore, I was quite taken aback when I saw that the ICC thought that in Libya, that had been under dictatorship for 40 years, one could try people who had been connected to the dictator before a national court. I know it takes generations to raise judges. You have to be taught by your senior colleagues and understand. And this is how I got to understand this as a young man, only 24 years when I was on the bench the first time. I saw the seriousness with which the senior judges went about their daily work. That made an impression on me that I've carried with me all my life. I wish you all the best. Thank you very much.
Thank you. I have Felicity Wong, Mariana Matt, our African, just a few minutes. We have three before. Okay. And Felicity, do you want the handheld mic? So can someone with the handheld mic bring it? And while it's doing it, I want to just make a comment. The coalition has been for the last 6 years strongly supporting the efforts on veto restraint and a code of conduct for exercising the veto on war crimes, crimes against humanity, and genocide. There's 2 initiatives, one the French-Mexico initiative and the ACT initiative. These, I think, are extremely important. 114 governments have now signed up to the codes of conduct. The key is, can you get the elected members of the Security Council to stand up to the veto members of the Security Council? It is a huge, difficult issue, and but we will remain working on it now. Felicity Wong was the legal advisor for New Zealand in New York at the first days of the negotiations for the Rome Statute. I think the whole way in which we were able to interact with the ad hoc preparatory process in the UN is significantly impacted by you, Felicity, so please.
Thank you. I guess I'm a kind of non-person now after so many experiences with non-papers 25 years ago. You know, I raised my roses and I listened to opera looking at the ocean in Wellington. I'm blessed, really, that we live so far away and so safely in such a Hobbiton existence. For those of you who may have seen The Lord of the Rings, I live in Hobbiton and every 20 years kind of venture out to the world. And you know, it's such a pleasure to have come here yesterday, and I've never been to the Hague and I've never been to the court. It was a dream, it was an idea, and I'd just like to really congratulate all of you and all of you people here who worked for more than 20 years and actually made the court a fact. It's a fact. And we live in a post-fact society in Western economies. Largely in the United States and Britain, what we have is a post-truth development. And I think it's important because the United States and Britain, historically, were at the forefront of developing legal responses to crimes against humanity and so on from the Second World War and even before. So I think it's important to look at the political and the context in which the court now exists as a fact in the legal traditions of those countries. And I apologize to colleagues from Africa and elsewhere where maybe my focus is not so much on that area. So what do we do about that? It seems to me that there is work to be done in capitals. We talked about universality, so there's a big job to be done to establish judicial assistance so that more states can join and that we have the universality that we had of the Geneva Conventions. And I'd just like to say we've been there before. In 1945, the Red Cross was set up and a large part of their mandate was to get the universality of the Geneva Conventions. And in Hobbiton, where I live in Wellington, the Red Cross now takes second-hand clothes, and my local store, I noticed the R has fallen off and it's the Ed Cross store now. So there is a revival and a thinking to be done about how we create a new network of organizations in our capitals that advocate for the ICC. So work to be done in capitals. I think there's obviously work to be done here in The Hague in the court, and Kim talked about this, and Hans Carell just slightly referred to it. The court can't become a Christmas tree that has every decoration on it that falls over. It has to really, really focus on the successful elements. And then Fabrizio talked about the big elephant in the room is arrest, you know. What's the point of having a court if you've got no kind of criminals? And I think the answer to that, The answer to that is public opinion in the United States and in the UK and other Western democracies, in addition to elsewhere. But actually, you know, I transited Los Angeles airport to get here. I had to take my shoes off. I was fingerprinted 4 times. The photographs of all my fingers were photographed. I was photographed. They asked me what I was doing. I had to answer that I was coming here. I was only off the plane for an hour to come from New Zealand to here. You know, there's a massive organization and a technological organization in a post-fact world over there that needs to be involved and re-engaged with. And then my last point would be this point about journalism and the media and youth. You people, or my former colleagues, have wonderfully built a temple here in The Hague, and I think the task is to support journalists and young people so that in our post-fact economies and cultures, that reality is something that they associate with and that gives meaning to their life. And I can tell you young people are hanging out for that. But it's a media job and it's a largely visual job. But I think it's worth doing. Thank you.
Thank you very much. Mariana Pena and
Good morning. My name is Mariana Pena. I've been working with civil society on the ICC for the past 13 years. And I think I'm part of a generation that is caught between Rome and today. And I see there are several of us here in the room. Somehow a generation that's been caught between optimism and skepticism. And possibly my remarks will show that. I wanted to offer a few reflections on the other mechanisms, the idea of the ad hocs, something that was mentioned by a number of you on the panel and a number of the persons who spoke and asked questions and offered comments. Let me first say that I'm a big fan of other mechanisms and ad hocs. As it was said, the ICC cannot do it all. I'm also a big fan of justice close to home, close to victims, close to where the evidence is, close to the context where judges and prosecutors can apply the law to the context because they know it so well. So let me just be really clear about that. But I may be a bit pessimistic. Let me caution. I fear that at times we could be heading into ad hocs and other mechanisms as an alternative to the ICC. So there's nothing wrong with supporting other mechanisms. What I worry about is when that is an option not to support the ICC. Why? Because ad hocs are predictable. We know what their geographical scope is likely to be. We know in most cases what their temporal scope is going to be. And in a way, it's easy for states to say, oh, that is in line with my national interest, so I can support that. Instead, the ICC requires blind support. It requires support to a number of situations, some of which may be in line with the national interest of certain states, and some of which may not. And it requires blind support with the future. So on a day like today, I wanted to remind ourselves this is why an international and permanent criminal court was created, to incarnate the idea of the rule of law and the idea that we are all equal before the law. And as we see that this world is changing, I thought that that reflection was pertinent today. Thank you.
thank you very much. We'll have this gentleman first and then Amnesty.
I'm Mr. Louis-Dor Capitaine Lukula. I'll speak French. Je suis coordonnateur du Bureau d'études et de réflexion pour le bien-être des communautés, BERCO en sigle, et membre du Club des Amis du droit du Congo. Je sais que la défense n'est pas sexy, mais permettez-nous ici, pour que je n'oublie pas, les deux réponses, je les voudrais du côté de Mr. William et Madame Kimberly. Cette cour, elle existe pour les victimes. Mais j'aurais voulu, symboliquement, parce que nous sommes porteurs des opinions de la société civile, que nous observions une minute de silence en faveur de toutes ces victimes, en faveur de laquelle cette cour a été créée, afin d'éviter que cette cour, qui est un espoir, ne devienne un espoir sans lendemain pour les victimes et leurs familles. Je demanderai au Mr. Williams si c'est possible d'inviter l'Assemblée d'observer une minute de silence en faveur de toutes ces victimes. Le dernier commentaire que j'avais, je crois le 6 ou le 7 à New York, lors de la 16e Assemblée, Madame la procureure, Mr. William, avait animé une table ronde. L'Université de Washington nous avait posé une question précise. Combien d'argent avez-vous besoin pour accomplir l'ensemble de vos missions? Cette question a été posée aux responsables. Je voudrais savoir quelle a été finalement leur réponse écrite et quel est le suivi. Là, c'est pour permettre aussi à Mme Kimberly qu'elle fonde avec moi et toutes les victimes pourquoi 20 ans après, nous trouvons encore des arguments pour ne pas évaluer l'efficacité ou l'inefficacité de notre cours. Je vous remercie.
Comme Fabrizio, je veux répondre en anglais parce que j'ai le même problème avec mon français. But yeah, the point you raised, and it was raised previously, are extremely valid. Of course, the victims, of course, there is a need to be able to, an urgent need to be able to assess the court, its efficiency and its ability to deter. And it is a long time to say that after 20 years we still can't do that. But I think the important point is that we need to continue to give the court a chance to develop, because we're talking about an institution that is extraordinary, that is new, that is global, and to try and assess its impact when much of the 20-year period, a good portion of it was the startup of the court. We can do the assessment, and there are critics doing it, and that's fair. The court should be subject to criticism. But if we want the full picture, if we want to achieve the full effect of the court, we have to be open to the possibility that it's still going to grow and it's still going to develop and it's going to improve. So I certainly don't suggest by any stretch that we shouldn't be critically evaluating the performance of the court, that we shouldn't be looking at the question of whether it's having the necessary effects, whether it is sufficiently delivering on its mandates. All of that we must be doing as we go along and learning the lessons, and that's part of why we're here today. My only point is I think it's unfair to the court to come to a strict conclusion on whether it's fulfilling that role, to conclude that evaluation today, because we need more time. But I don't in any way suggest, and I'm always open to the dialogue and the criticisms and learning from lessons. That's very important. But the only point is, let's also be fair to allow this institution, this important institution, not to be devalued because we come to conclusions too quickly. It's growing, it's changing, and it's responding to the criticism, and we've certainly seen that, especially in the last few years. So that's the message that I was trying to convey.
If I can add one point, perhaps only because it's not widely known, but the court has developed in the past 2 years performance indicators to measure how it's delivering, to measure the quality of its output. So we do it in the Office of the Prosecutor, Chambers do it, Registry does it. We present that as part of our governance system to the Assembly of State Parties and to the Commission for Budget and Finance, so we are accountable. Every year we explain, this is what we should have done, this is how far we went. And that is, all that is part of way we're functioning today. It's a relatively new development, I acknowledge that. It's something over the past 2 years that we're working on this, past two, 3, but it's now part of the way we do business. So just...
Thank you. I have on my list Amnesty, Human Rights Watch, our colleague here. Just to, on the last comment, I think the coalition would love to see the Assembly have performance indicators. And this could be, in a way, a kind of universal periodic review mechanism where the state parties agree to come forward and have a certain review of how they are achieving their own goals in implementing the Rome Statute. But Matt and Amnesty?
Thanks, Bill. As you say, Matt from Amnesty. I think I'm one of the, what I would call the people who I hope you will pass the baton on to at some point. I wasn't in Rome, I was a teenager. I was more concerned about the World Cup. If you're interested, England went out to Argentina on penalties after we had a disallowed goal. And I'll come back to that this afternoon when we talk about the future and who we need to engage with. But on the first point, I wanted to talk about the Rome Statute and to some extent the lessons that can be learned from that. And I think one of them, and we're seeing it in the drafting of other treaties, I'm thinking, for example, of the Mutual Legal Assistance Treaty, where what we have is a group of perhaps small middle states, like-minded, who are willing to draft these treaties and put together these mechanisms where the major powers with their major interests are not willing to do so. And I think that's a very interesting thing to think about going forward, particularly for situations which may not be able to come before the ICC and others which are unpopular. And again, it won't surprise you that I move on to talk about the new Syria mechanism, which was adopted by, again, a smaller group of states through the General Assembly due to the egregious failure of the Security Council, which comes on to my second point. So just to finish on that point, I'd be interested to hear from the real experts on the treaty drafting about what lessons can be learned to push through these effective treaties when the major powers are not interested or don't want to be part of it. But that doesn't mean they shouldn't. It doesn't mean we shouldn't try. On my second point in relation, was about the strategic thinking on international justice, which is that obviously the ICC can't do everything. So then there's quite a large dependence on national jurisdictions to do so. I think what is lacking somewhere is someone with an overall strategic vision of how that will happen. Clearly, universal jurisdiction might be quicker, it might be lower level perpetrators, and international justice will take a lot longer, but you'll get the most responsible maybe in an international mechanism. What I'm not seeing too much is that strategic thinking going on. And I wonder which group of people would do that. And lastly, on the UN Security Council, I mean, as I said, we've seen an egregious failure of the Security Council. I think a couple of comments on that in relation to the ICC. The first one is, of course, that often the selectivity that the ICC suffers apparently from actually can be laid at the foot of the UN Security Council, and that's deeply unfair, but I don't think the narrative is mistaken. And I think quite often the court is blamed for the failures of the Security Council because that's politically more expedient and also is easier to put the knife in the court. So I think that's an interesting thing to discuss. Another one in relation to the Security Council would be its, let's say its double standard, because most of, if not the two resolutions I can think of, have only tried to carve out jurisdiction for certain people and not those on the Security Council. What does that say about selectivity of justice and universality? And also doesn't pay for it. So it says, well, we'll refer it, but we won't give you any money for it. Do it yourself. And then the court says, well, we don't have any resources, and we say the court's failing. I mean, again, these are the honest discussions I think we should be having on the Security Council, which takes me to my last point, the General Assembly. Because if we're seeing a Security Council that is utterly deadlocked and failing in its responsibilities, what role can the General Assembly play? Of course, it's inherently more political, but as we've seen with the Syria mechanism, if it's a way to bypass that deadlock, maybe we have to do it. And for the states parties on the Security Council, what leadership role can they play? What leadership role can states parties who come in as non-permanent members play? And when they're being elected to those positions of non-permanent membership, could there not be a requirement for those electing them to say, well, what's your position on the ICC and international justice? That might be a good one. And I think some states already do ask those questions. But these are really the things going forward. I know it's far too much to discuss, but thank you.
Thank you. And as we go to Human Rights Watch, just to indicate, we're in Europe. We've just had Italy be on the Security Council. We now have this host country. Netherlands is on the Security Council. Sweden is on the Security Council. And the court, I mean, they're elected by the General Assembly to be on the Security Council. And the court itself, the treaty, is a product of the General Assembly. So I think this whole issue of the relationship of peace and justice in the General Assembly is important going forward. So Richard Dicker.
Yes, I wanted to thank all the panelists for their very thoughtful comments that just give us much food for thought and reflection. I had a question specifically for Fabrizio, premised with a comment about arrests. And I certainly was very pleased to hear, Fabrizio, your reference to the lack of proactivity and the lesson to be learned from that. The comment being, I hope that we don't become rigid in drawing lessons about success on apprehension of suspects, particularly just trying to replicate the experience of the ICTY, where, of course, the European Union's willingness to use conditionality for membership in the EU was such an effective tool. I suspect that we will not face in the future, or currently now, opportunities where such a ready-made tool is available, and it will require creativity, innovative thinking to be able to press states parties to use the powers that they have in pursuit of apprehension. And specifically, the experience that led to the arrest of one Charles Taylor and his surrender to the Special Court for Sierra Leone, well worth studying what the measures were that persuaded former Nigerian President Obasanjo to arrest and surrender Mr. Taylor after he had lived in comfort in that country for years. So I think we need to look on many tracks in terms of lessons that can be learned. But the question, Fabrizio, is just, again, you gave a very, I think, careful, insightful account of proactive posture by the court is not enough, and states parties' role very much needed. What can you say? There are limits to what can be said in such a forum here, but what can be said about thinking on the part of the office of the prosecutor in terms of approaching state parties to make arrests a more viable and effective option to secure their cooperation? Thank you.
Thank you and good morning.
Excuse me, we'll do the answers to these questions as we do the final roundup, just so that you know.
My name is Virgil Ivan. I am a Romanian national. During the Rome conference, I've been one of the vice presidents of the whole committee chaired by Philip Kirsch. So I can say that I've been a colleague of Fernandez Gurmendi, who who is now the president of the court. I'm a professional. I'm not a diplomat. I am a justice professional, meaning in my country, Romania, I've been a prosecutor for many years and a judge. Currently, I'm working in a project financed by European Union and covering North Africa, 8 countries from North Africa. This project is called Euromed Justice, and is dealing with capacity building of judicial system. And now I can link my intervention to the panelists' interventions too. So I will speak, and I have some comments on lesson learned from other jurisdictions, and I'll use my perspective as a criminal law experienced professional. And I will refer to this judicial cooperation in criminal matters, which is the essence, and I think that one of the objectives of the International Criminal Court and its complementarity is to go a little bit deeper, meaning to try to obtain the cooperation not only for the states, but to try to obtain the cooperation from professional networks of judges and prosecutors, which exists at the regional and even at cross-regional level. It's extremely important, of course, to obtain this cooperation and coordination, to build the capacity at least 4 levels. First level, and the most important, is to coordinate the judicial institutions at national, domestic level. Without coordination among judicial authorities at national level, cross-border cooperation, it's impossible. The second level is the regional one. So you have to connect the judicial authorities at the level of regions. And the third level is cross-regional. That's Euromed Justice, is trying to connect the judicial authorities from one bank of the Mediterranean with the other one, with the European Union. And the fourth one, and that's a global one, it's the level which is created by the United Nations. To give an answer to the interrogation raised by Kimberly Prost, what is UNODC doing? I just coming yesterday, I've been in Vienna in a UNODC meeting dealing with an expert group meeting dealing with digital evidence, how to obtain digital evidence. Digital evidence, of course, focusing on organized crime or counter-terrorism, but also in international crime. And today I'm here, and the next week I'll be in Brussels to discuss again the coordination between different projects financed by the European Union dealing again with digital evidence. So, of course, here we are among colleagues. We are at different professions, from diplomats to academics to practitioners to professors to civil society to NGOs. We have to maintain this holistic perspective. And again, we have to go in the courts, as a lesson learned, has to go closer to the network of professionals. And we will ask, which are those network of professionals? Eurojust, it's a network of professionals. IBER-RED, it's another network from South America linking prosecutors. You may find a lot of information there. You may find access to evidence, because 2 things are extremely important for any criminal investigation and prosecution. To gather evidence, and together the evidence being very protective to fundamental rights. Those 2 things are absolutely essential for the progress of national justice and criminal justice. And I'm extremely honored and grateful. And it's a little bit strange for me, because I've been a trial prosecutor and I'm a lecturer in Luxembourg in an institute dealing with judges and prosecutors, to have a high emotion. But I feel very proud and extremely honored to be invited here and to cooperate for a long time, 20 years, with the Coalition of International Criminal Court just from the beginning. And believe me, in Rome, I've been a prosecutor from a country called Romania. Of course, I've been director for judicial cooperation, but in that position, I've been able to cooperate, and I'm very proud of what we did together. Thank you very much for your attention.
Records.
Thank you very much, Klaus Sackwitz from the International Nuremberg Principles Academy. Congratulations to the coalition. And Fabrizio has put it on the spot. No ICC without the CICC. That should be up there, and you should get all the credit for that because you did a tremendous job. And I sometimes hope that civil society on other areas develops the same power. Now, as Kimberly Pross said, what is the relation or what is the influence of the Rome Statute on the system next to the ICC? And I think it has an impact in the way that there is no excuse anymore not to do anything. And we see that on the number of ad hoc tribunals. They wouldn't exist. The Kosovo court, financed by the EU, wouldn't exist without the Rome Statute. Well, you can't go to the ICC for legal reasons, but you have to establish something that looks very much like the ICC. I think this is the success of the statute. It takes away the excuse not to do anything. After Nuremberg, for 5 decades, people simply said, oh, sorry, there is no mechanism, there is no IMT, there is no nothing. Only the Security Council with the ICTY overcame that. And immediately afterwards, the work on the Rome Statute began. And that is, I think, the milestone. Not so much the details, we will discuss them in the course of today. And I have a lot of observations, which I will spare you now from. But for me, the most important thing is the fact that we do have a statute in place, that there is no excuse not to do anything anymore. And if it serves as a blueprint for another court, be it the regional court or something else, so be it. One word maybe on complementarity. And it has been said it's not the job of the court to promote and to pay for complementarity. Well, it is the job of the states parties for sure. That's crystal clear. It might not be the job of the states, but we should have in mind that complementarity is easily set and very difficult to achieve. I had an interesting meeting roughly a year ago in Brussels with the Justice Minister of the Central African Republic, and we were talking about establishing and supporting, setting up a special court. And he said, well, we don't have any court at the moment. They are all destroyed. All the books are stolen. We don't have any case, criminal ordinary case for the last 3 years. So it's not only about setting up these glorious courts for international crimes, it's bringing judiciary to the people. And my last point is a trap in which I run from time to time, and the coalition runs into it, and speakers ran into it. It's not peace versus justice. It's peace and justice. And if we continue to play one against the others, both will lose out at the end of the day. The question is maybe which comes first. But it should always be clear to everybody, it's not peace against, it's peace and justice. Thank you.
Can we do the Ben Ferencz video at this point?
This is a year in which many organizations and individuals will be celebrating the 20th anniversary of the signing of the Rome Statute for an International Criminal Court. I recall very well when Kofi Annan, Secretary General of the United Nations, heard about the signing. He described it as the hope for future generations, and it certainly was. Well, 20 years later, we can begin to ask ourselves, what did we hope to achieve? What have we achieved? Where do we go from here? We are making significant progress, thanks partly to the Coalition for an International Criminal Court and the splendid work done there. I want to particularly congratulate our friend William Pace and the Coalition for an International Criminal Court for its enormous success in holding together hundreds of non-profit organizations dedicated to the same goals. The court is in existence, despite the fact that many people have told me beforehand, you were trying to do the impossible, Ben. The world will never accept it. Well, I've learned that you can do the impossible. Nothing that's new was possible before it was created. Despite the best efforts of many good people and the fact that we have a court, it has a long way still to go. It is a mission, but it's not mission impossible. I can't believe that we lack the capacity to recognize that law is always better than war.
Thanks. And so now, Ben Ferencz is 99. He was sending also a birthday greeting to another member of our organization who had just had his 90th birthday, and so the edit is we did our best, but he was one of the original prosecutors in Nuremberg, and he every day is still fighting for this court and for the rule of law to replace war on our planet here. So we will conclude now by going across. We'll start with Fabrizio and hopefully be able to finish at 12:30. Then I'll have just a couple of comments. We'll do a minute of silence this afternoon in our last session. I think that's the most appropriate time. And Fabrizio, please.
Thank you so much. Richard, that was a very provoking question. We're not, I'm not, by no means I was referring to some sort of, cutting and pasting exercise. Obviously, it's absolutely true that the particular political conditions in the Balkans at the time favored that particular political form of pressure on the Balkan states to deliver. It's a way that I'm not suggesting for a second that being more proactive in the ICC OTP means creating a tracking unit that mirrors the one that the ICTY OTP had, because we operate in a completely different environment. One thing is when your territorial jurisdiction is limited to former Yugoslavia. The thing is when your territorial jurisdiction is, 7 situations in different parts of the world with completely different geographies, threats, risks. So what we're talking about more proactive is thinking out of the box, developing strategies, thinking more aggressively how to promote arrest in the context of our cases. Which involves, among other things, for instance, deepening something that we have been doing for a number of years already, our networks with other law enforcement agencies, both national and regional. And I welcome the words by our colleague from Romania. We have been working with a number of these networks already for quite some time. And there's some room for optimism there. Even in states that are not really interested in cooperating with the court, a local prosecutor is. The law enforcement colleagues typically want to do exactly what you want to do from the ICC. They want to deliver justice. They want to see justice being done unless they're completely subordinated to the political powers, which obviously can also happen. But we have seen it in countries such as Kenya, for instance, that basically, government not interested in cooperating with us, but the local prosecutors were. Now, they have limits as to what they can do. And at the end of the day, the fundamental question is, we may be able to work with local prosecutors, with local NGOs, with a number of others to try to promote an arrest strategy. But ultimately, and that's the problem with arrest and surrender, there is a political decision. And that's where state parties have to start discussing what they want to do. There has a conversation that has to start. And that conversation has to, for instance, include thorny issues such as, what are the costs of non-compliance? A judicial finding of non-compliance by judges of the ICC has to be worth something. It can't be any relevance. So what are the consequences of that finding of non-compliance? What's going to happen once the state is faced with the other states in the ASP? What is the ASP going to do with that? That conversation has to start. Failure to cooperate with the court, failure to arrest someone can be gratis, can be for free. There has to be some consequences. And that is we can work on the technical and law enforcement aspects of arrest. Someone else has to work on the political dimension. That's not our job, clearly. But if I can, very briefly, for 1 second only, one of the questions was, how do you, what advice can you give in terms of drafting of a multilateral treaty of this type? And I'm going to use this to honor 2 dear friends and colleagues who are no longer with us. Because it has been said for years, and it's absolutely true, that one of the secrets of the success of the Rome Conference was the unique partnership between civil society and government delegations. And to my mind, that is epitomized by Christopher Hall and his unique contribution, but not only in terms of pushing us to get to do the job done and to do the right job, but his constant help. I mean, I remember turning to Chris every time saying, give me ideas as to this, or tell me, do you have any precedent that we can use here? And this encyclopedic knowledge of international law being put to this common cause. And you also needed, as Silvia Fernandez said, young, talented, enthusiastic government delegates. And I can't think of a better example than Håkan Freeman, the builder of bridges between legal traditions, the thoughtful, young Swedish judge that would always come with a great idea, with something that could save you in the 11th hour. So we have it thanks to wonderful people like Christopher Keith Hall and like Håkan Freeman.
had to hand with Håkon, didn't you? So I'll be very brief. I just wanted to say that I'm really delighted that there were responses to some of the questions that I raised. There was comments on some of the comments that I made, because what a wonderful way to start off the 20th anniversary year, because this is what we have to do. We have to ask questions, we have to discuss, we have to disagree, because that's the way we're going to find some strategies for moving forward with the court. So I think we've so much that has been discussed this morning. We should carry on that conversation, and hopefully we can take that forward throughout the year in many different forums moving forward.
Well, there were no questions for me.
Because you were so persuasive.
I'm not sure if I should comment on this, but maybe I will. There was a comment about what lessons could be learned for arrest, using Charles Taylor as an example. I'm not sure if Charles Taylor should be an example for the ICC.
I wish to, first of all, to thank all of you for your attention and for the many ideas, suggestions, comments coming from the floor, and I'm sure that the coalition will have taken good note of all of these. I will not address any particular question or comment, but I wish to close with a general reflection, as this session tried to concentrate on the past and the present while looking at the future. Sometimes we may fall in the trap of thinking that everything was rosy in '98 in Rome, and that now there are many clouds in the horizon. Well, not everything was rosy at that time. And let me just mention a couple of things. On the eve of the Rome conference, the chairman of the chiefs of staff of a very, very, very important country, I don't need to name it, sent a letter to his colleagues in the main alliance led by that country, I don't need to name the alliance, pointing out that what was going to be drafted in Rome was very dangerous for the safety and security of soldiers, ensuring our defense. So that was what the British call, I think, a shot across bows in the tradition of the British Navy. But the reaction of the heads of defense of the staff, this was published at the time, but not sufficiently, I think. Especially, I think, in some European countries, and also I think the New York Times, the reaction was, this is not our business, this is the business of political leaders, civilian leaders. We obey, in a democracy, we obey civilian leaders. So it was really a great lesson for their colleagues across the Atlantic. Now, this was before Rome. After Rome, mainly I would say after the big terrorist attacks on 11 September 2001, there was an attempt, by that time it was looking that the statute was going to enter into force. So there was an attempt from the same country to smother the child in its cradle. We remember that? It was with that label, smother the child in its cradle. It was a strategy with several points. An anti-Hague law, invasion of the Hague law. That law is still in the books. A resolution in the Security Council to protect all, not only soldiers, but civilians, etc., from countries not state parties to the statute. Those resolutions were adopted for 2 years in a row, and on the 3rd year, then we managed to stop that. And Spain had a certain role, and also Romania, I must say. And there was also a campaign to get bilateral treaties from state parties in order to shield also the soldiers and citizens of that important country. Now, at that time, in 2002, 2003, 2004, the states parties, the Assembly of States parties, the like-minded countries, and the coalition were totally united in not only protecting the integrity of the Rome Treaty, but also promoting actively ratification and legislation, etc. We managed to surmount those challenges. Now we'll have other challenges. Felicity mentioned post-truth. We have entered an era of post-truth. There will be lots of attacks. Now that the court is engaging in the matter of Afghanistan and also Georgia, not to speak of African cases. So now the threats will be more diffuse from various parts. But we must remain united and proactive and determined in protecting the integrity of the statute and of the court, and continue promoting universality. So we have our program ahead of us. Thank you.
If you will join me in thanking our presenters for this first session. So. In the last page of your program is a list of the restaurants nearby for our lunch break. And I wished I knew the answer to the one that is here in the Peace Palace, but I don't know how to get to it. So we will be on our own to some degree. In closing, I want to mention yesterday I had forgotten, and as we mentioned, Christopher and Hakam, and you could go on for, unfortunately, a long list, but I want to mention Rhonda Copeland and how much she contributed with the Women's Caucus leadership, and Medard Wellamera, who was fundamental importance from South Africa and Tanzania, but for the SADC countries. And so later today, when we do this moment of silence, I hope we will have these wonderful people in memory. So this afternoon, then, we're going to have the 2 sessions on assessing the Rome Statute system 20 years out, challenges to progress in the fight against impunity in today's geopolitical landscape. We'll have a break after that, and the last session on the future of the Rome Statute system, the International Criminal Court, and international justice. We very much join in thanking all of you for participating. We hope that you will join us this afternoon for the sessions. I know some have indicated that they especially would like to see the 3rd session and participate in the 3rd session. And this actually worked, where we were able to do presentations and get a number of interventions and answer the questions from the participants, and that is what we've wanted to do. So with this, I will like to close this first session today and look forward to seeing you this afternoon at 2 o'clock. Thank you very much.